Thank you, everybody, for coming to our May monthly membership meeting. Today we have a special presentation by Larry Henkel of the Henkel Law Group on discharging tax debts in bankruptcy. Larry is a triple gator. He received his bachelor's, JD, and master's in tax from the University of Florida, so congratulations, go Gators. He also has taught at the University of Central Florida Graduate Accounting Program, topics of business law, taxation, and at the Rollins College MBA program, business law. He's published a couple books, some journals, articles, and he has been speaking for over 30 years on these topics, and he's going to present for us today. We did receive CLE credit for this. I have the sheets on the table, and I will give you the number at the end of the presentation. Just as a matter of housekeeping, any of the CLE presentations that we put on and videotape, if you watch the videotape within the year, you still can get CLE credit. So you don't have to be here, but you do have to watch the tape at some point. But we prefer that you be here. With that being said, I'll just introduce Larry and let him get started with his presentation. Thanks, Larry.
I may not be the only one that's done this, but I came in with a phone, and so I had to go take it to my car, but I went to Starbucks, and apparently I'm not the first person to do that. I said, sure, well, hold it, what's your name? So when I leave, don't forget to remind me to go to Starbucks. Get my phone, I'll get 2 hours up the road, and remember it. Is this okay to pick me up on that?
It will pick you up.
Okay. All right, we had to, when I gave the outline, we had to break down some discussion here. They break out the outline for how long we're going to speak for the Florida Bar to approve it. But we don't necessarily have to spend that much time on what a Chapter 7 bankruptcy is. Anyone not know? Okay, good. So, but there are a couple things that I do want to bring to everyone's attention. So, my work is probably 90% fighting the IRS and for all kinds of things. People hadn't filed returns in ages, or companies that don't pay their payroll taxes, audits, appeals, large tax debts. We do some offers and compromises for people of lower income and no assets. Just as an aside, offers don't work if you make a lot of money. Most of my clients make pretty good money, and that's why bankruptcy can work so much better. So the bankruptcies that we do generally are just to discharge taxes. And so there's a couple things I want to make sure that everybody realizes on the first page. Let's see. Number 4, the assets that are exempt under bankruptcy law do not apply to the IRS. So the homestead exemption does not apply. A tax lien will attach. They may or may not take the house. They rarely do. In my 31 years of practicing, I think I've had 2 or 3 houses seized, and they were by bad people, tax protesters or criminal tax evasion, that kind of stuff. So your general run-of-the-mill case, they're not going to take the house. However, before the statute expires, if you sell the house or refinance it, they'll get their money then. So you've got to keep that in mind. Similarly with whatever other exemptions like IRAs, that's not exempt to the IRS. The IRS can do what you can do. So since you can cash in an IRA, they can take the money too. There may be situations where you've got a husband that usually owes the tax debt and the wife doesn't. And it's not chauvinistic, that's just the way it always is. Husbands get in trouble and wives don't. If you have a joint bank account, because the husband could write a check and take everything out, the IRS can take everything out. The other thing I want you to realize here is never file an adversary proceeding against the government to discharge the taxes, okay? As we're going to go over, there's like 5 major tests. 3 or 4 of them are date related, and if you meet those, just let the insolvency unit process it. The other one, evasion, if you've got a client that makes pretty good money, you don't want to file an adversary proceeding, because then the government, it goes literally make a federal case out of it. You get some hotshot Justice Department attorney who's going to look for evasion. and they're gonna look to see if your client belonged to a country club or paid private tuition, and say, well, gee, that's evasion, you should have paid your taxes. The insolvency unit doesn't really look at those kind of things, so don't file an adversary. And then afterward, if they don't release, abate the taxes and release the lien because they say there's evasion, then you can always reopen the case and file your AP then. My career, I've only had 2 times we had to do that. One of them is ongoing right now. And there's the phone number. You wait about 60 days, call that insolvency unit and confirm that they've abated it and see if they'll release the liens. Something that may be somewhere else, tax debts do not count as consumer debts. So when you're working, if you have to go through the means test, tax debts are non-consumer debts. That's paragraph B2. So let's go to the second page. Now, you know, I'm going to do this a little different. Go to the third page in the middle, paragraph F. Pretty much what everybody wants to know, this is a very complicated area of law, and I could, like, impress you or bore you with, all the statutes and all that kind of stuff. But what people really want to know is, when a client comes in my office today, is this tax debt dischargeable or not? So you have to look at every year and analyze it. So look at paragraph F. It's got to be an unsecured income tax. And we're going to come back and I'm going to talk about what's secured and unsecured. In order for it to be dischargeable, the return has to have been filed. And all these rules, in essence, are to give the government a fair chance. They got to have a fair chance to try to collect before you can wipe them out of bankruptcy. Okay? So this makes sense. If you haven't filed a return, they've never been notified that you owed any money. It's not fair to get rid of it. So one of the requirements is that you file a return. We're going to come back and talk about SFR, substitute for return. They don't constitute returns, and I will spend some time on that. So the first thing is that you had to file a return. Okay, so let's say your client filed a return last Tuesday and they want to file bankruptcy today. Is that fair to the government? No. They need some time after you filed the return in order to try to collect before you can bankrupt it. Well, how long do they need? They need 2 years. So this is what is called the 2-year rule. It has to have been at least 2 years. So today is what, May 21. So you need to make sure that it was filed at least May 20th, 2013 or earlier. If not, it's not old enough. One of the ways you can make more money in your practice is when you run through these tests and the IRS is a major creditor and you've got to wait 3 months or wait a year or something, then maybe it's not a bankruptcy case today. Get a power of attorney and represent them with the IRS and work out a payment agreement. I actually give a lot of seminars around the country to bankruptcy lawyers trying to teach them how they can make more money in their practice by adding tax problem resolution to it. And you don't have to have a tax degree. It helps if you're going to do audits or appealing audits. But most of it is just procedural knowledge of the debt and how you handle them, either through bankruptcy or offering compromise or a payment agreement. And if you can do 7s and 13s, you can do that kind of work. So if you don't meet one of these tests, get a power of attorney and work out a payment agreement. All it is just one particular creditor. Powerful creditor, but nevertheless. Don't be afraid. My license tag down on my car is Beat IRS. Those are the 7 letters I've had it for like 22 years. And it's just to give clients the confidence that I'm not afraid of them, So you've got to have that confidence and you can do this. So that's the 2-year rule. Then the 3-year rule. If there's one rule that most people know, or a lot of people know, if they don't know all the rules, it's the 3-year rule. They frequently don't have it right. Because a lot of people will measure like from December 31. And it's not. The 3-year rule is measured from the due date of the return. When was it due? April 15.
What about extension?
Or there's an extension to October 15. Now back prior to 2005, there was another one, it was August 15. Okay? So you can get all this from the transcripts. And then there's some little nuances, like if the 15th was a Saturday, you start the next business day. We usually use the 19th because invariably, without having to look it up, Patriots Day, in Boston or DC, that's, I don't know, I think the post offices are closed, but it's a federal holiday. I don't know. So we just use like the 19th. But it's 3 years from that date, okay? And so you gotta wait. So right now, if we were looking at 2011, just focusing on the 3-year rule, is that dischargeable today? Just looking at that one. Yes, if there was no extension.
You mean the 2011 tax year?
Tax year 2011. Just focusing on the 3-year rule.
Not necessarily.
Right.
If you had extension.
It depends if there's an extension. Okay? If there was no extension, then the 3 years was up April 17th, 19th, whatever, of this past April. If there was an extension, then we have to wait till October. And that's where there's malpractice in this area. Because I had, in fact, I actually was the plaintiff's lawyer on this, where we sued a bankruptcy lawyer because he filed 2 weeks too early. He filed in like September 28th or whatever. It had been more than 2 years, but he didn't know about the 3-year rule. And so there was $70,000 not discharged. And the E&O carrier just wrote a check for $50,000 after like 2 phone calls, because it's that clear. All right, so that's the 3-year rule. The other one is that it has to have been assessed at least 240 days. Okay?
Or accessible.
No, that's a different rule. If it's been assessed, it has to be assessed 240 days. Now, where does that come up? That comes up with like a subsequent audit. So you may have the 3-year and the 2-year rule met, but then there's an audit going on and they assess it. You got to give the government a shot. How long? 240 days. So I've got a client, and here's the thing, if they don't file a lien within that time, then you may get away with being able to bankrupt it and keep all your assets that are exempt under Florida law. So I have a client right now that has about $1.2 million, I think it's around $600,000 in IRAs and $600,000 in paid off condo, all exempt under Florida law, not exempt to the IRS if they file a lien. So back in, I think it's like December, he had a $750,000 tax court judgment against him. So we waited for it to get assessed. Then we're waiting 241 days, which would be in August. And if that 241st day comes before they file a lien and we file bankruptcy, he'll get to keep all those assets. If they file a lien before, then it attaches and he loses it.
Is the attachment because of the statute that gives him that right? Is that the Kraft versus U.S. versus Kraft?
No, Kraft had to deal with
T by the E.
joint, with the right, T by E. No, this is just, there is no liability on an audit. So when you file a return, there's a liability for whatever tax you show. Then if they audit you, there's no liability until the audit's over and signed off and officially assessed. To discharge that, in addition to these other rules, you've got to wait 241 days. Okay? And then the last one is, there can't be any fraud or willful evasion. And we all know, the criminal fraud is beyond a reasonable doubt. Civil tax fraud is not beyond a reasonable doubt, it's clear and convincing evidence. Maybe that's like a 75% chance that you did it, okay? And if you get assessed that, that's a penalty that's 75% of whatever the tax is. So it's huge. And then it makes the tax and the interest and everything not dischargeable. You can have a case where they don't assess the civil fraud penalty, but they object in bankruptcy court to your discharge, not your discharge, but discharge of this debt, because the government feels you have, by a mere preponderance of the evidence, that's the standard, evaded the payment of tax. The case law on that is really bad. It's like if you pay for anything besides groceries and the bare necessities, the country club membership or the private school for your kids and that kind of stuff, the government feels like you should be paying them and not that. And so that can make it dischargeable. That's why I say don't file an AP, because you're going to get some Justice Department attorney, and most of them are bright, hardworking people that didn't take the job to settle cases. Why do you take a DOJ tax division job? So you can fly around the country and try a lot of cases and take depots and, you know, be a real lawyer, you know, all that kind of stuff. And so they're not looking to settle cases, they want to try cases. And they got a client with an unlimited budget. So you're going to have somebody there looking at the file, the audit file, and the collection file, and they're going to see what your expenses are, and they may object because of that. So don't do that, because the insolvency unit doesn't look at that. Unless there's some other indicator on the file, they don't look at that kind of stuff. They're just looking at the 3-year, the 2-year, and the 240-day rule. Okay? So that's it. I think I can head back now. I mean, that's it. Those are the 5 things. So on any day that you're looking at, you just look to see if those tests are met. And if they are, you're good to go. And if you're not, you got to wait. Now, if it were just that easy, right? So paragraph G, the tolling provisions. So this guy named Young, he had a tax debt, and while he was waiting out the 3-year rule, he filed a Chapter 13. I call it kind of like hiding in Chapter 13, because the IRS couldn't touch him while he's in there. And then about almost 3 years into it, he got out of the 13, waited a little bit, and filed Chapter 7. Hey, I met my 3-year rule, discharge it. And that went all the way to the Supreme Court, and under that like fairness that I was saying, well, gee, it really wasn't fair to the government. They couldn't try to collect from you because of the automatic stay in the bankruptcy. So that's not fair to have the time clicking away in that 3-year rule. So they said, okay, we're going to equitably toll that. So the amount of time that you're in that bankruptcy was going to toll it. Okay? So then BAP CPA came along, and they codified that in a couple of provisions. And that's in 507A8G, which are the priority rules. And I was trying to give you the nice, easy checklist without getting into lots of terminology and sections. So there's codification of tolling in the priority section. The priority rules are just the 3-year and the 240. And so they've codified that for the period of time that the IRS couldn't come after you due to a bankruptcy or a CDP, a timely CDP. I'll come back to that. Or in one case, offer compromise. Plus a certain period of time. So what you have to do when you have the 2-year rule and the 3-year rule met, you then have to find out, well, was there also, before those time periods were met, was there a bankruptcy or a CDP hearing that tolls it? You got to find how long that tolling event was and add 91 days. Okay? Not to bore you with a lot of details, if the tolling event was an offer in compromise, you add 31 days. Okay, I'm going to give you a real easy way to figure this out in a minute. Okay? Now, statutorily, there's no tolling for the 2-year rule. Under 523, that's where they have the no discharge rules. These are 523 is here's what's not dischargeable. If you never file a return, it's not dischargeable. And that makes sense. Okay? If you filed a return late and within the last 2 years, it's not priority, it's not dischargeable, like a school loan. Okay? So that's under 523. There's no statutory tolling in that section, so most people that work in the area and study it and all that kind of stuff feel that there's no tolling there. The government feels differently, and the government has now taken the position that there is equitable tolling in the 2-year rule. And I've gotten to know real well somebody in the insolvency unit, and he said that the government programs are being rewritten to have tolling. Now here's an issue. The Young decision just said tolling, but it didn't say how, how much more you add to it, if anything, because it wasn't relevant. Just the time period that Mr. Young was in bankruptcy was enough to make it not dischargeable, so they never had to raise that issue, okay? And you want to know, so if you're trying to tell your client, hey, this, $100,000 tax debt's going to be dischargeable, but there was some tolling, and the statute tells you, add the time plus 91 days. You can get your calendar out and count it. So if the government is applying equitable tolling to the 2-year rule, are they using Young, which never said anything about adding more time? Or are they just counting the time in? Or are they also going to add 91 days like the 3-year and the 240? I don't know. Which doesn't give you a lot of comfort. So you have to be aware of that issue. And on the top of page 4, there are some other cases that talk about equitable tolling of the 2-year rule. So what we've done so far is just take a high, spaceship or helicopter view looking down on this area. These are the tests. You had to have filed a return. You had to have filed it more than 2 years ago. It had to have been due more than 3 years ago. It was assessed more than 240 days. No fraud and evasion, and you've accounted for tolling. If you meet all those, ostensibly, it's going to be dischargeable. You have a question?
Who's the tolling for the offer and compromise?
The tolling for an offer and compromise is in 507, and it only comes up if you file an offer and compromise within the 240 days of when that tax is assessed. And then you add the time you're in the offer plus 30 days. So if you waited at least 240 days from the assessment and then did your offer, there's no tolling. And the offer doesn't toll anything else. So one of our strategies that we do is if we're dealing with somebody that's got a big liability and we need to wait out the 2-year rule, the 3-year rule, we might wait for the 240 day to go by, file an offer and compromise. The government's not going to take collection action while you're doing that. The key is they're not prohibited from taking collection action, so there's no tolling. But it keeps them busy while the other things are clicking away. Okay?
Does it matter what kind of offer and compromise it is, whether it's an ETA offer or a DAT?
I believe the question is, I'm going to repeat it because of the camera. Does it matter what type of OIC? I don't believe it does.
What are the types?
Well, the 3 types are the one we all probably know about. Doubt as to collectability. Hey, I can't pay this, which would be another good topic if you guys want to do this. And if we have time, I can talk about that too, some, because it's good stuff. Better fees, did I mention that? And or doubt as to liability, I don't owe it, or effective tax administration, which means I could pay it, but it's not fair, and so you ought to let me pass. Someone here may have different experience. I think it's the same as a unicorn. It supposedly exists, but nobody's ever seen one. Have you ever had one in ETA? Accepted?
I kind of use DATC with ETA because it's not prohibited, and I've won on a doubt as to liability one.
Doubt as to liability, yeah.
Yeah.
But not an ETA.
I've used it
You used it,
in
but
conjunction with DATC.
call me, take a picture, bring it to the local zoo. It's like the unicorn. I've never seen one. It's like I had an old lady, and I brought her in, and she's one of these, white-haired, 5'2", like Aunt Bee. Some of you go watch Nickelodeon, you know who Aunt Bee is. And her husband had died. She had some life insurance that she needed to live on. So yeah, she could pay it, but she wouldn't have any money to live on. That's what an ETA is for. Denied. So, I got to give the guy credit to sit across the table from his grandmother and say no. That took guts. Any other question right now?
So when a client comes in and says, I talked to the IRS, they said I'm not collectible, does that mean that they were in an offer and compromise?
No, that's a good question.
Because they have it all the time.
Yeah. The only options for a tax debt is either pay it, make payments on it until the statute expires or you pay it off, or bankrupt it or settle it. or Belize. Those are the only options. So when they were figuring out what you can afford to pay, they may very often say, well, because what they're going to do, they can take like almost everything. They can take everything but like $150 from your paycheck. So they can take everything. But they will allow you necessary living expenses. You know, the means test came from the IRS. You know, all those figures came, we've been using those for years. So those are the figures. So what they figure is, well, based on your income, and make sure you have enough for current taxes, here's how much we're going to give you for food and housing, blah, blah, blah. Hey, there's nothing left to pay us. We're going to make you CNC, currently not collectible. And they'll leave you alone for a while. Penalties and interest continue to accrue, but they'll leave you alone. And that's great if you're, you know, if you have a future bankruptcy client, because you can get them into a CNC status or maybe $100 a month or whatever it is, whatever they can afford, then they leave you alone and those things are clicking away. And being on an installment agreement does not toll the bankruptcy things. There are some things that toll the statute of limitations, the 10-year statute of limitations, that don't toll the bankruptcy. Like if you're out of the country for at least 6 months, then it tolls the collection statute, but it has no impact on bankruptcy. I've had timeshare salesmen out of Orlando, you know, and we would, you know, set them all up and do a future bankruptcy, and so they would go to Cozumel and sell timeshares. Because they get like, it's about a $90,000 foreign earned income exclusion, and they're making about 100 whatever, so they save a lot of taxes, they're living in Cancun, and that doesn't toll, and the IRS leaves them alone, because they're out of the country, and that doesn't toll for the bankruptcy, and then they'll come back and file bankruptcy. Look, good taxpayers, you know? So, part of what we do also is clean these people up. They're kind of a mess. There's a whole program we put them through to get them, you know, cleaned up, especially doctors, the worst. You know, they spend, sometimes I think it's the doctor's wives, or doctor's second wife, that spends a lot of money. Yeah, I had one guy, I forgot what his practice was, and his house payment was $15 grand a month. So that's about $180,000, and because of Medicaid and all this kind of stuff, he's only now making about $225,000. So it's like, you can't even make it work. But his wife didn't want him to sell the house. Time to sell the wife. All right, so let's go back here a little bit. Let's talk about a secured tax debt. Because I get a lot of questions. People are concerned, they, you know, say someone's got a $100,000 tax debt and they see a $100,000 tax lien, so they think it's secure. So they think in a 13 they need to provide for this in full, okay? Or that it's going to survive because of survive a Chapter 7 because it's discharged. Not everybody. So that's not the case. Just because there's a tax lien doesn't make it dischargeable. I mean, doesn't make it secured. So what do you have to do? In order for a lien to be, for a debt to be secured, there has to be a tax lien filed. And there has to be equity in property to attach to it. So, you know, a typical consumer case, the person may not really have any assets to speak of, but maybe they've got a $100,000 tax debt. It's all unsecured, okay?
You file a motion to determine secured
No.
status?
No, in a 13, when they file a proof of claim, they typically will list the IRS will usually list the IRS as all secured, you know, because of the tax lien. Then you just call them and say, no, if you look at Schedule A and B, we only have, you know, equity and assets of X dollars. And that's what it should be secured for, and they'll usually amend their claim down to that amount. Okay?
Or you go through an objection process if they don't.
Yeah, you're right. You can object it. I've never had a problem because, you know, unless they're contesting the value. Actually, I just had one where there's another tax lien, and they're saying, well, they've got a term policy, life insurance policy, with a $100,000 face. I'm still not figuring out what's that got to do with it. You know, the value of a term policy up till death is zero. Her kids are beneficiaries. It's still, you know, I don't know if there's something the trustee's trying to do, something sneaky like seize the policy, change the beneficiary and kill it. That's the only thing I can think of.
So you can sell some of them off though, and they've said
Yeah.
that's cash value. If you, like a viatical used to.
Oh, yeah, if there's cash surrender value, but this is just a term policy, so I don't see how there's, it may attach to it, because it does attach to all property. And I guess that's a property, but I don't know what you can do with it, because doesn't mean you own it, and the owner can change the beneficiary. Another thing you want to do in these kind of things is advise the clients that they've got life insurance policies, and let's say husband and wife owe a tax debt and they've got life insurance policies on one of them or both, whatever, and they're naming the surviving spouse. That's not good because they got a big tax debt. So what you want to do is set up a trust and name the trust as the trustee of the trust as the beneficiary. And then the trustee can say, all right, I'm going to provide for all your living expenses. You follow what I'm saying? As long as they don't die, it's fine. But if they were to die with this tax debt and they named each other or their estate, then that's money for the IRS. So, if you don't do their work, just find someone that does it, nothing fancy. It's just a simple trust that their oldest son or brother or somebody that, clients will often say, well, how do I know they're going to do that? I said, this is why they call it a trust. They don't call it a, cross your finger. It's a trust. You've got to trust your trustee. And then have the trustee be the beneficiary of your life insurance policy. I have another client that owes the IRS about $7 million in civil penalty, which is not dischargeable. And his wealthy father left everything in trust to benefit him and his kids, but left his wife as the trustee. I thought, boy, that will guarantee a good marriage. Think that one. Okay. Any questions about the secured tax debt and what you have to do? One other thing is, for real property, that lien must be filed in the county where the real property is located. Okay? So, if they file a lien here in whatever county, what is this county? Lee County. If they file a lien here in Lee County and your client owns, a vacation home in North Carolina, it doesn't attach to it. Okay? Now, I don't know what that does for you unless, you somehow make that your permanent residence, and I don't know, North Carolina's unlimited exemption and all that. Anyway, it's a fun discussion, but I don't know where it gets you. Well, where it gets you is in Orlando, there's a section north, most of Orlando's in Orange County. There's a section north of Orlando that's in Seminole County. The town of Winter Park is 90% in Orange County, but 10% in Seminole County. And I did have a client who lived in the Seminole County part, and the IRS saw Winter Park and recorded it in Orange County. So it didn't attach to the home in Seminole County, and we could have, if different facts, but if he had filed bankruptcy, he'd been able to keep it. Okay? So don't be afraid of the existence of a tax lien. Look to see if there's equity. Any questions about that?
So once you've got the lien discharged, the IRS tax lien, do you go back to your client and say, well, listen, it may be still on the county record, and this is what I can do to
Yes.
clean it up?
Technically, I'm going to repeat the question. Technically, once you get the tax discharge, the debt discharge, not the lien. Okay? So the lien survives, and they're under no obligation to release it. They typically do. That's when you call the insolvency unit, and they'll typically release if there's no assets, or just assets that they're not going to take. They're not going to come in and take the couch and the clothing, even though it attaches to that. They'll release the liens. Okay.
That's in chapter 7 too, if you
Yes.
say, your claim is not secured because of these facts.
That's right.
And they'll
They'll release the
voluntarily
lien.
agree that the discharge applies to them, and they'll release the
Yes.
lien.
They don't have to, they just typically do.
And
Okay.
do they do a satisfaction or give you
No,
something?
no, it's a release.
Okay.
It's a separate document. Now, just yesterday, I had a case where there was some Pennsylvania tax debts that were discharged, but Pennsylvania won't release the lien. It's only like $3,500. They won't. They're not. We're not going to. They don't have to. Can't make us. No, was the official word I think he used. So, and so I had to write a letter to the guys trying to buy a house now, and I had to write a letter to the underwriter that lien doesn't attach to anything except what he owned at the time that was exempt. So it doesn't attach to the house he's going to buy or anything like that. The only way they'll release it, it's like extortion, is come in and pay it. So either go pay the $3,500 or use this letter and hope the underwriter, you know, smart enough to understand it doesn't affect their title or anything like that. Okay, anything else? Yes, sir.
Yeah, if someone doesn't get an extension and so they file their taxes late, I'm confused, it seems like it's gone.
I'm gonna come to that,
Oh,
the
okay,
late
that's
file
fine.
return. Okay. So on page 2, now I'm laying out a little bit more of, in fact, I probably ought to put page 3 in front, you know, give it the way I like doing it. I like starting kind of general and then kind of drilling down to some of the details. So on this page 2, this is what we're talking about, the priority. What are priority? And we know priority is not discharged in a 7 or a 13, it must be paid in a 13. I've been corrected, technically priority taxes are dischargeable in a 13, but because you have to pay them in full, you know, I don't consider them as dischargeable because you got to pay them in full, right? So these are the priority. They're the newer income taxes. Notice I see the 3-year rule and the 240-day rules. I call them the newer income taxes. And then as the other gentleman referenced, the other one that is priority is the tax that is not yet assessed but still assessable. So, for example, on the case I have in Miami, if we were to have filed the case before, let's say we want to do a 13, maybe there's some reason we want to do a 13 and they haven't gotten around to assessing it yet, but we know what the dollar amount is, we could go ahead and file and it would be priority. Okay? It's also priority if we wait for them to assess and it just hasn't been 240 days. So the newer income taxes. Trust fund taxes are priority. Now the other ones, they all age. You know, if you haven't met the 3-year, the 2-year, well, it's not the 2-year here, but the 3-year and the 240, am I speaking too fast? You can wait for them to age. The trust fund penalty never ages, okay? That's a whole nother hour-long presentation. Everyone know what a trust fund penalty is?
Yes.
For those of you who don't, if a company, does not have to be a corporation, if a company has payroll taxes and it doesn't pay it and it goes out of business, the people who are responsible can be personally liable for the trust portion, which is the amount actually taken out of paychecks. Okay? It's called the trust fund recovery penalty.
Is it 100% penalty?
It used to be, like, you're my age, you remember that. It used to be called the 100% penalty. And it confused people, so they changed the name. I'm sure Congress or the IRS had a big committee and they, you know, spent $1 million and came up with a new name. The 100% penalty, trust fund recovery penalty. That's not dischargeable in the 7 or 13, must be paid in full. Okay? That might be one of the areas you do more of your offer and compromises for. Okay. Then the next page, this is the 523, what's not discharged. That's the ones where you didn't file a return, or you filed it late within 2 years, or the fraudulent returns. Okay? Now, let's go to page 4, paragraph H, the gentleman over here. Yes, ma'am.
So the fraudulently returns, is the statute of limitations open for 25 years or forever?
On
And
collection,
can you distinguish it with the criminal tax, you know, the
it's not 20,
tax evasion?
it's not 25 years. The statute of limitations on a false return, I think might still be 10 years. But, by the way, all of these rules are administrative. The IRS is just following its administrative rules. Before the 10 years is up, they can also sue in district court and get a judgment that's now good for another 20 years. Starting to see a little more of that I hear in Miami. And I had a former client of mine in Orlando got that, where he owed about $4 or $5 million for trust fund for a bunch of failed restaurants and hotels that crashed after 9/11 because Orlando's such a big tourist area. You know, when people quit coming, you know, we had like 55 Denny's restaurants and 12 hotels, and you know, they went under. So they can sue you and get a judgment. Doesn't happen real often. Okay, now this gentleman asked, there's this whole thing about substitute for returns, SFRs. I've heard other people call it service prepared returns. I kind of like that too. They're not dischargeable. And when you get the transcripts, in order to do all this, you must get an account transcript. So let's talk about that real quick. You either need to get a 2848, and in tax circles, That's how you call it. It's not a 2,848. Just like you don't tell someone you're going to your 341 meeting, you know. It's a 341, you know, that's just the way you say it. So it's a 2848, that's a power of attorney. Or you can get an 8821, and that is a tax disclosure form. It means you can't represent your client, but they're allowed to disclose information. You can have that filled out in the name of your firm, and then anybody in your firm can get the information because you're going to be on hold a while. There's a couple ways to do it. You can get registered for e-services, which if you do this a lot, I just finally did it. But the difference is when you send in the power of attorney, you got to wait about 5 days for it to get on file, and I'm impatient. I don't want to wait that long, you know. Or you call the practitioner hotline. I think that number is in here somewhere. Well, write this down. 866-860-4259. Until I've called it a few times. 866-860-4259, yes.
Do you need a CAF number? I know you need a CAF number for the 2848, but do you need a CAF number
For
for
the 8821? The question is, would you need a CAF number? No. They'll give you one. A CAF number is CAF, Central Authorization Function. It's just where in Memphis they keep track of all the attorneys, accountants, and everybody, and they all get a number. And if the first time you file one of these, you'll get one in the mail and just put it on there in the future. So you call that number, you wait about an hour, and then the guy picks up and goes, all right, oh, and he accidentally hangs up, you know. Often enough that, you know, I bring it up. So be prepared. Call at 7:30 in the morning or late at night, maybe get West Coast people. And then you'll fax it to them, and they for about a year and a half now, they always say, we only help, you know, they're only helping people if you're actively trying to help your client's tax problem. So are you actively trying?
Yeah.
Yes.
Of course.
Who's going to say, no, I'm not? You know, but, you know, so you say, yes, I'm actively trying to resolve my client's tax problem. And then you want to get account transcripts faxed to you. Not record of account, not a tax return, record of a return that shows all the numbers on all the lines. No, an account transcript. And if you're really going to get into this, you're going to also ask for wage and income information for all years they haven't filed. Because clients a lot of times haven't filed. You know, a bread and butter case for us is we get some haven't filed, we prepare all the returns, we get them under an installment agreement, start doing estimated payments, and we do a bankruptcy in 3 years. So we make 3 times the money on each, well, each one is higher rate anyway. Offering compromise is minimum $5,000 to $7,500 to $10,000. So it's a lot better than bankruptcies, at least that is.
But you also have to keep them in compliance for 5 years, so you're kind of chasing them.
And you
all
charge for
for
that,
5 years.
right? Don't you? Yeah. If you're going to do their tax return every year, or you know, if you have an accountant next door that you're buddy with and you're going to send business back and forth. What she's referring to is if an offer is accepted, there's like a 5-year probation. They have to go 5 years, file on time, and pay in full. Okay? Well, many of my clients have never gone 5 years in their life without a tax problem, so they get to be repeats. Yes, ma'am?
Do you ever have clients who have defaulted installment agreements?
Yes.
And then do you charge for that too?
Why wouldn't
Do
I?
you charge when you put them back into?
Sure. She's asking would I charge if they screw up and I have to fix it, would I charge for it? It's not Chapter 13. You keep charging it. You keep, you know, in advance, non-refundable. Okay, so under the substitute for return, if you don't file on time, the government has no way for that particular year, they can't collect. Because they can't collect until, you know, you file a return with the tax due. So never file a return, there's no tax due, they can't collect. Simple, out. So to prevent that, they say, Congress says under 6020B, that the government can prepare a substitute for return based on information they have so they can generate that liability and collect the tax. And the only thing they know about is W-2s and 1099s. So they're going to assume, and I literally had this happen to me, I got a IRS notice that I owed $300,000. And I puckered up. It's like, you know, I do this for a living, and it's still like, what the hell? And what it was is, because I talked to my accountant, I sold a house and it was tax-free because it was, I owned it 2 of the last 5 years, it's tax-free. And so you don't have to report it anywhere. Well, the IRS gets a 1099-R and says, well, Mr. Hinckley, you sold this house here. We don't know what you paid for, there's nothing. So the CPA firm changed their procedures that they're going to start reporting this. And I'm surprised that I was the first one to, IRS has no idea it's your principal residence and all that. So if you don't, they go, well, I don't know what I sold it for, but, we don't know what you paid for it. So they assume zero, and they assume short-term capital gain. And so if you're a salesperson, you made $100,000 1099, well, they know that's income, and they just assume that, you had no expenses because they don't know you had your opportunity to file a return. So these returns are usually inflated, okay?
And that means the penalties and interest are all inflated.
Everything's inflated. So whenever they assess that, it does not start a 2-year clock. It's not a return, it does not start the 2-year clock to discharge it, okay? So, if what you can do is you can file a return showing the numbers, they almost always accept them, and they'll reduce it down to what should have been owed once you file that return. However, most case law says that's not a return. And I'm not really sure what our judges say. I actually wondered if that's why our good judge is not here, because I would be trying to influence what future cases should look like.
I thought that, because this all comes out of the hanging paragraph at the end of 523.
Yeah.
And I thought that the problem was, there was actually a Judge Bain's case where the difference between an offer, an agreement where you sign it, the 6020A, and an SFR, there's a difference here because you don't sign the SFR.
That's
you
right.
Swear. And I thought that was just a codification, but now they say
No.
if you're a day late.
Well, no, that's different. That's different. I'm going to come to that.
Right.
So the SFR is not dischargeable, but you can come in and file a return and get it to the right amount, and they'll reduce the tax and penalties and interest. But you can't discharge it then, okay? Now, the difference is there are dischargeable SFRs, I call it. When you get the account transcript, it's sort of like how it starts is, let's say February 1, somebody at the IRS says, well, Mr. Heinkel never filed a return for 2009, so we've got to do an SFR. So they open a folder, it's like us opening a case, and they record everything in these transcripts. And so there's a code 150, substitute for return. That doesn't mean that's the assessment, it just means they started the process. And let's say it was February 1. Then they have to send you a 90-day letter, which was ignored or whatever, and so it might not get assessed, a code 290 usually, until let's say October. That's when it's an assessment. So if you filed your return in July, they might take that return and assess it, in October or whatever, but it'll still show as a substitute for return. Okay? So just because it says, and how you can tell is, at the top of the transcript it says 1040A, and then the first line is a code 150, substitute for return, and a $0 amount. Okay. So that's, when you see a 150 substitute return, $0 amount, that's a substitute for return. It does not mean it's not necessarily, it's might be dischargeable. I used a double negative, couldn't fix that. It might be dischargeable. So what you have to find is, and this is where it's difficult, did the person file an original return before they made the assessment? And if so, it's accepted as a dischargeable return. Still subject to the McCoy rule that I'll talk to, okay? But as far as the IRS, because the IRS does not follow McCoy. Now, I don't want to know what McCoy is, I'm going to come back to that. But so you can still discharge an SFR if you file the return first. And there's some ways you can kind of guess. Number one, ask your client, because they're such reliable sources of information. If there's an assessment under a code 290 and then later a reduction, probably that means they got the return afterward, accepted it, and reduced their inflated number. So you're probably out of luck. But if the original return was filed and one assessment not changed and it matches the return your client has, then you're probably okay. There is a code 599 return filed, ignore that, because that's the IRS's return that they prepared. It's not your. So if you're going to work with a client, now if it's only $2,000, you're not going to waste your time. Maybe, maybe not, who knows? But if it's a big dollar amount, yeah, I'm not really sure it's malpractice, because if they filed afterward, it's not dischargeable anyway, you know. But there are cases that say under, I think it's called the Hindenburg or the Hildenburg. Hindenlang, thank you, Hindenlang case, that no, if, it doesn't matter if they prepared an SFR against you, if you filed a bona fide return, signed under penalty of perjury, and blah, 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 that's a return. That's what I think the rule should be. And I do like sometimes when judges sit in, because I can talk about it, you know, and they have to listen. You can't, you know.
I had a corollary to that. The IRS has a manual, and I don't know if this provision still exists. It says when you have an SFR, then you file a 1040, that the 1040 becomes the return for all purposes.
Exactly.
And if that's the case, the argument is you may have assessed it under the SFR, but now you've reassessed it under the 1040,
Yeah.
and if the IRS has that ruling, they got to follow their own rules, and they can't. And the
Yeah, and we don't have the time to get into exactly what he's saying. Is there's a whole bunch of case law, and you know, because when it's assessed, it says in the code even it says this shall be good and valid for all legal purposes. Well, why not for bankruptcy? So I really don't think that's good law where they say that you can't, and you know, because then the category it falls under is non-dischargeable. Just like damages under a hit and run DUI. Is it the same gravity? I don't think so. So you need to be worried or concerned about that, or just not give an opinion, you know. So you know, the SFR, I really don't know, okay? I think where you could get in trouble is if it was a dischargeable SFR and you didn't wait for 2 years. So you do kind of need to find out if the person really filed a return, and frankly, you're going to need to probably charge them more money and either hire someone like me or do it yourself or whatever. I don't really like doing that part, because you got to maybe do a Freedom of Information, a FOIA request, Freedom of Information Act, and request the audit file and dig and see what you can find, you know. So it's a bit of a problem. Now the McCoy rule is an issue where they said if you file it late, even 1 day late, it's not dischargeable, even if the government hasn't filed an SFR. Because they don't do SFRs until like 2 years down the road. And McCoy, the Fifth Circuit case out of New Orleans, said, no, if you're 1 day late, it's not dischargeable, period. That's just stupid. That is stupid, because why would we have a code section that says, well, if you file late within 2 years, if it's not dischargeable ever because it's late, why do you have this 2-year language? It makes no sense at all. None. Unfortunately, 2 other circuits follow it. I don't know. The IRS doesn't even follow it. Okay? So where you're going to have trouble, though, is if your client has state income taxes. Now, I gave this talk to the Atlanta bankruptcy lawyers, and there was somebody from the Georgia Department of Revenue. That's the 11th Circuit, and they hadn't ruled on it. She says, that's tough. We are following it. We're going along with McCoy, because the states are on a roll. So you got to be careful of that. All right, so that's a whole lot of stuff. Everybody, is it clear as mud, or is it clear? Yes.
They can file an SFR even if you file the return?
Well, it's because they started the process.
Return came in.
Yeah, and so things are crossing in the mail. Once you file the return, they haven't started. No, there's nothing crossing in the mail. So the other thing, any questions about this? It's very confusing, and it's a very difficult area of law. So if you go to the last page, there is a website you can go to called Tax Discharge Determinator. Has anybody heard of it? Good. How many people here use Best Case? Okay, and the Best Case users, you haven't heard about it yet?
There's a link on there, isn't it?
Yeah. Yeah, they've adopted it, and I'm trying to get, and so has Legal Pro. I created it. It's the only, I'm very proud, it's my baby. It's the only web-based software program of its kind. And it took me about 3 years on and off to create it. And I got, spoke to all the experts and asked questions that they didn't know. Like Morgan King, he's a friend of mine now. And he said one day, well, I'm glad you're not in the live audience asking these questions. Because, you know, it's like at the level that I'm talking here, to most people that don't know much about it, you're going to talk at a certain level. But all of a sudden, if you're writing a program, like what if I have two tolling events and they overlap? Do you count the overlap twice or once? He never thought about that. Nobody's ever thought about it. There's no cases on it. Nothing. So I made my way. I met a guy in insolvency. I said, well, what does the IRS do? They only count it once. So there's certain things that I built in here. Then I had to hire a coder to do the coding, and then I would create the website. It is so simple. You guys have used it, right? Simple?
Yeah.
All you get is the account transcript. You don't have to know anything. It'll just ask you to create what I call a session. So it might be, you know, John Smith, 2008. And then the first question is going to be, is this an income tax return? If you say no, you know, you can't discharge it. Is yes, then what year is it? What, you know, and then it says look for code. So look for the code 150. What's the date? Look for code 460. What's the date? Look, and it tells you to look for codes. Only the codes that are relevant. The rest are immaterial. And you just enter the dates. And then it gives you a summary page, and that's your chance to review it and make sure you didn't make any mistakes. And then if you were happy, you just hit submit, boom. It gives you what I call the magic date. This is the first date that tax is dischargeable in bankruptcy. If you file before then it's going to be potentially priority or non-dischargeable depending on what rule isn't satisfied. Just last week, I uploaded a completely revised answer because it was really geared to Chapter 7, and people had questions about 13. Now when it gives you, it says, all right, on this magic date, it's dischargeable in 7s and 13s. But if you don't wait to do a 13, how is it going to be treated? Because everybody's asking. It's extremely complicated. But has anybody seen the new answer yet? You had to use it last week. Because it's going to give you the magic date when all three tests, 3-year, 2-year, and 240 are met. The last one out there is the magic date because you're going to meet them all, right? This is if you file before that, how do you treat it in 13? Well, it depends on which ones of those three are satisfied and which ones aren't. So, for example, if it's not been 3 years and not been 2 years, well, the 2-year means it's non-dischargeable. The 3-year means it's priority. Which one rules? The priority rules. It'll still be priority even though you haven't satisfied the 2-year rule. So it now gives you the answer if you file before that date. It says, well, if A and B are met but not C, here's how you treat it. If A and C but not B, you know, that kind of thing. So it's really, really helpful. And I put a lot more treatise in there than I wanted to because it had a lot of people that did not, you know, I had people say, well, what schedule do I put it on? I never thought I needed to tell someone.
And
You know?
and Larry, that's a flat fee that you can build into your fee structure.
Absolutely.
too.
When you register to use it, you get to use it twice for free, and then you pay. And what most people do is they buy 10 sessions at a time. It's $297, called $300. So $30 each time you use it. If you're not charging at least $30, because you got to get the transcript and you're giving an opinion and all that kind of stuff. So if there were 4 years and it cost you $120 to use it, and you're charging $1,500 and you're done in 15 minutes, well, as soon as you get the transcript, you're done like that. That's good billable, you know, valuable billable time. It's more profitable than anything else I do. And so hundreds of people are using it nationwide, and the Best Case and Legal Pro both adopted it and they're marketing it now because there's nobody else has this. So, you know, try it because it avoids malpractice and you can make money on it. And, you know, and then some people say, well, the client can't afford that. Geez, I'd do it out of my pocket. You know, why would you? Has anybody done it by hand? Does anybody know all the rules and done it by hand? It takes a lot of time, doesn't it? It takes a lot. The lady in the back, did you raise your hand?
Yeah.
Yeah. It takes.
And then you're still not sure. I mean, you think you followed all of the rules, but then you can maybe say you're to follow chapter 13 where IRS is going to tell you what's dischargeable, what's not. But
Yeah.
in chapter 7, you never know. If it's a no asset case, they don't file a proof of claim.
That's right.
And then you call them up and you talk to them, but most of the time the person is, you know, they don't know anything. They don't want to talk to you.
That's correct. So even when you know the rules, it saves time and it's a double check. And like I said, once in a while, I I would do one and I, by hand, just to like check it once in a while, and I come up with a different date program. You know, I haven't done it by hand in 3 years. In fact, if anything, I would say I get a little rusty on the rules because I never need to look at them anymore. And my paralegal does it. She does them all, you know, boom, you're done, you're quick. So that program can make you money and save you malpractice, and it's like, you don't have to know all this kind of stuff. Just rely on this. For IRS problems, I do get tons of referrals all over the state for people that are in trouble, and so you have my card. If I can help you or whatever, please let me know. Does anybody have any questions? I can stay. I've got a little more time on my parking meter. Any other questions? Okay.
Thank you, Larry. The CLE number, write this down. I also have the sheets up here if you don't get it down, and please take one of Larry's cards. He lives and dies by referrals. He was kind enough to travel here from St. Pete to give us this presentation, so maybe we can return the favor somehow. The CLE number is 1501241, N as in Nicholas. And that concludes our meeting. Thank you very much, everybody.